On the immediately on reopening, subject to correction, business page 44 of our affidavit. Any of the affidavit your lordship may kindly take.
It is directed to be listed on a non-miscellaneous day in July 2000.
That's an NMD. That's NMD. That will be taken up, obviously.
So I will only be relying upon the affidavit filed by the Backward Classes Commission. For the purposes of the present submissions I make, I don't need a rejoinder. I will rely on the information furnished by them, the pleadings and the documents filed by them to indicate, without having to contest any of the factual premises or the conclusions they have arrived at by way of a rejoinder.
But can we go into that at
Yes.
stage?
Yes, at this stage.
When Supreme Court, they went to Supreme Court, there is no stay.
Now kindly see the reservation.
There is no stay, sir.
Yes.
So today they will place the report before the Supreme Court.
Yes, we are placing that.
The ground before the Supreme Court,
Yes.
that once the order has not been stayed,
No.
question of this entire procedure is a nullity,
Yes.
because
Now,
it is in violation of our order.
Yes. Now kindly come to the interim order or the reserving of the liberty order of the Honorable Supreme Court and the Backward Classes Commission's understanding of the liberty that has been granted, as has been stated in the pleading.
Sorry, I'm so sorry.
Now kindly come to page 47 of the affidavit in reply filed by the Backward Classes Commission.
Yes.
Opposition, sorry, affidavit in opposition.
Which matter? Which matter?
In 111.
Triple
In writ petition number 111, Amol Chandra Das.
Yes.
Now the Backward Classes Commission understands the liberty to be unhedged by the pendency of the Supreme Court proceedings as far as revisiting the entire matter is concerned. I will indicate to your lordships from the pleadings of the Backward Classes Commission, and I will place it before this honorable court that this is an exercise without prejudice to the contentions there, but in compliance of your lordships' directions in the division bench. And if they maintain before your lordships that it is in compliance with the division bench's recommendations, that SLP for the purposes of this exercise may not be relevant, because they are before this honorable court in pursuance of my writ petition saying we have taken whatever contentions we have taken in the SLP, but without prejudice to those contentions, on the basis of the advice received by the Backward Classes Commission from the learned Advocate General, they have decided to comply with your lordship's directions to proceed with a revisiting of the entire process. Now, if this is a revisiting of the entire process, that earlier identification having been eschewed, if this process is to result in the notification of the communities for the purposes of the schedule or for the purposes of public employment, the Supreme Court's canvas or the contours of SLP would not comprehend the present exercise which has been done. That is their understanding in the petition.
Now, without disturbing my learned friend, is it the contention that compliance of your lordship's order makes the SLP infructuous?
No.
Unfortunately, that is not the law.
That is not the law. But
therefore, everything is open before the Supreme Court.
Now, my lords, therefore,
and that is why the Supreme Court was informed.
I'll just make
because it creates an impact on very many things. My admissions, the other recruitments, promotions, everything. So we cannot, everything cannot come to a standstill. Therefore, my lord,
may I just make one submission?
Now,
therefore, everything is before the Supreme Court. If my learned friends have any grievance, they have very many grievances. Let it, my lord, await at least till the end of July.
Now, my lords.
May I one submission? One submission.
1 minute. Let him.
May I make one submission? Your lordship was pleased to pass an order on 6th of May to continue with the process, having regard to the law laid down by your lordship at paragraph 360 of your lordship's judgment. We are complying with your lordship's direction. Now, my lord, if your lordship takes the applications, I do not want to argue on the applications without any affidavit. My lord, naturally, because my lord, pleadings are not complete. Even if we take the applications as they are, my lord, these applications are nothing but application for modification, variation, or vacation of your lordship's order. Nothing more than that. My lord, whatever, this is a second attempt made by the petitioners to stall the process. We want to comply with your lordship's direction. Obviously, my lord, the SLP is pending. We do not know what will be the fate of SLP. My lord, it is an argument of no, my lord, subject to correction by my learned friend. Perhaps this argument may not be correct because Supreme Court may either confirm, Supreme Court may also modify. So whatever reports we will be submitting, that would be a relevant material before the Supreme Court when the matter next comes up before the Supreme Court. Obviously, my lord, we are bound to place everything before your lordship because we are now in a process of complying with your lordship's direction. We are doing so.
There is a bit of a grey area, Mr. Mazumdar.
Right.
Whether the consideration or consideration of the propriety of the process undertaken by you
Absolutely.
will be examined by the Supreme Court or this court is what is being now, I understand,
But
being argued.
May I make my stand
No.
very clear? May I make my stand very clear?
Yes.
My stand is that I am complying with your lordship's direction. My lord, I am bound to, my lord, follow your lordship's direction and any further direction to be issued by your lordship. I am also bound to place all the material before your lordship, which I have tried to do so in my affidavits which I have filed today. So, my lord, the primary material is now before your lordship. There is no rejoinder to my affidavit. Now, my lord, this is now a second attempt. Now, as I pointed, I don't want to repeat myself. But, my lord, today, unless and until your lordship has the occasion to go through my affidavit and go through their rejoinder or their rebuttal, if there is no rebuttal, that is one thing. If there is rebuttal, then it is another thing. My lord, your lordship, perhaps subject to, my lord, I will stand corrected, will not be in a position to assess the entire process and to examine whether we have carried out the process in compliance with your lordship's directions or we have acted in derogations of your lordship's direction.
Mr. Counsel for the
Yes.
petitioner, what is it that
15
you
July
are
is the
praying
next date.
today?
Yes. Now, my lords, if they have stopped short of giving effect to their fact finding and placed the report either before this honorable court or the Supreme Court, one set of consequences would arise. They have acted on the fact finding done in pursuance of the liberty and have modified and amended the statutory lists under the 1993 Act. So therefore, if it is of no avail to argue for me today, I am asking myself a question. The admission schedule for the current academic year is on. The recruitments have been put on hold. Would the state government act on the present included list purportedly in compliance with your lordship's order? Or would the, I'm asking myself the question, or would the state be complying with the Supreme Mandal's order where the learned judge of this court has held that you have to revert to the pre-2010 notification for the purposes of conducting recruitment? It can't be that your lordships are disabled from scrutinizing it. It can't be that the Supreme Court will see it in July 2015. And in the meantime, a fait accompli will be provided to me where the newly reinvented, re-included communities...
No, they have given an undertaking. They will not do so.
No, that was, my lords, kindly see the undertaking in the contempt case, which is what your lordship's referring to.
That in all the departments,
Yes.
they will not be proceeding with any further.
Yes. Now, my lords, the admission schedule for the present academic year is in June. Now, if they are to comply with Supreme Mandal's order, then we are all happy with the consequences.
That has not yet come today.
Yes, my lords,
It has not yet come.
Yes.
That what will happen. State has not disclosed, subject to what you say. What you are arguing is that by keeping the matters pending, they would be inserting the new set and they will be throwing it upon the pending selection and recruitment process.
Yes. Now, if that my lords, if the state were to say that this is only a revisiting exercise, so
interim protection you want.
I am saying that these notifications, which have the effect of reintroducing the communities your lordships have struck down, shall not be treated as OBCs for the ongoing admissions in 2025. Because now I am just indicating to your lordships, it is not a pure and merited simple exercise of fact finding. They have placed it before this honorable court to abide by the verdict, or they want to place it before the Supreme Court and await adjudication. They have gone a step ahead and actuated the statute by accepting these recommendations and notifying the lists. Kindly see the CAM that I have filed. Kindly see what is left for the state to do is to bring in a consequential 3-line legislative amendment and present a fait accompli to me. Your lordships have said under 2H of the 2012 Act, it is read down to be in consultation with the Backward Classes Commission. So the Backward Classes Commission is consulted by the executive government for the purposes of incorporating these communities for the list under the 1993 Act. So the same list will be actuated into the 2012 schedule and we will be shown.
Subject to approval by the legislature.
Now, in my respectful submission, These findings will be the legislative fact for the purposes of the proposed legislation. I'm not interdicting legislation. It might come whatever stage it has to come. But this is not a pure academic exercise which has been undertaken by the state. It has resulted in a statutory consequence of the statutory list of OBCs being amended. As to whether this could have been done on the factual premise that has been undertaken, purportedly in compliance with your lordship's order, and there is no remote compliance, I will not have to seek to any rejoinder. I'll rely on the documents filed by them. I'll show their pleadings, I'll show their data, and I'll show each one of them is in direct violation of the formulations of your lordships in para 260, para 280, and 360 of the holding in 22/5/2024. This is not a vacant exercise trying to bide their time. It has resulted in a statutory consequence of the list under the BCC Act being amended. Now, I am affected because it alters the landscape of admissions as far as I am concerned, or the affected students are concerned. Now, kindly see the consequences. Your lordships have already dealt with those submissions as to whether a PIL could be maintained. I will indicate to your lordships that the same circumstances your lordships have indicated to hold that the PIL is maintainable in these matters continues to writ large. There is no publication of the primary data. There is no publication of the social enumerating factors. There is no publication of any of the applications filed by any of the intending communities. There is no publication of the Backward Classes Commission's reports, 4 of them. I am told, I'll indicate to your lordships, they are not even cursory. Your lordships have said it is a deliberative democracy. There has to be an application of mind. I'll indicate to your lordships that there is not even a lip service of consideration. 4, they have arrived at re-quantifying the reservation from the existing 10% to 17%. Now, that is an activity relevant for 2012 Act also. There is no state population figure. There is no population figure of any of the communities that have been identified. There is no contemporary figure of public employment and the people who have occupied those positions. 2014 is the freezing data. Between 2010 to 2025, 140 communities had the benefit of reservations. The data would alter. There is no data. But the state has decided that it will have to be at 17%. Your lordships have said, in the opinion of the state, adequate representation will be.
That has not yet been done.
That has been done. That has been done. I'll place before your lordship.
17%.
Yes, I'll place it before your lordship. I'll place it before your lordship. Absent population figures of everybody, absent public employment figures of the figures now included, I would ask myself, it could have been 25%. It could have been 33%. On what basis was it reduced to 17? The incidental replication of Section 5A of the Act. If they have to validate their action, they have to remove the basis of the judgment, or they have to await the Supreme Court ruling. They can't reinvent the wheel and recause the same consequences. I'll just take 3 minutes of your lordship's time to read 5 notifications they have issued, which is of some statutory consequence. They have not said that they won't be acted upon for the present year.
Sir, just tell us, suppose today, before the Supreme Court hears, whatever faulty method they have adopted, in derogation to our decision, suppose today they take a decision that yes, we have amended the schedule on the basis of this commission recommendation, and tomorrow all pending selection processes would be guided by this new data. That situation has not occurred.
That is the situation today.
Where from we will find.
Your lordships will see as to what is stated in the pleadings in the commission. I will indicate to your lordships as to what are the consequences arising from these notifications and see how imminent that process is, because they are not saying that the commission.
So then, sir, we have to give them an opportunity to reply.
As of today, if your lordships just gives me 3 minutes time, I'll indicate the ramifications of the exercise and its culmination in these notifications. If your lordship's conscience is satisfied that what is now required is the imminent process of legislative notification of these processes, then we are looking at an inevitable consequence to be provided as a fait accompli to me. I am not seeking interdiction of a legislation, but I am saying the factual predicate which is underlying the process is so flawed.
Where they have said that they will be implementing this in the.
Well, it's that in this particular. That is not stated in the writ affidavit. It is not their case now. that the present admissions in 2025.
That is not their case now.
No, I'm subject. Nor is it their case.
The one single judge has said that you follow the 66.
Nor is it their case now that they will be following the pre-2010 classification for the present purpose, because the pre-2010 classification is also amended now. 64 out of the 66 communities are reintroduced. They are interspersed between A and B. The entire landscape of the OBC figures has now changed. This is how far-reaching the fact-finding purportedly innocuous exercise has been left. May I just indicate to your lordships?
That legislature has, through the legislature, it had been done.
Yes.
Huh?
Well, let's kindly see what has been done in relation to pre-2010 classes now. Kindly see the notifications. I'll just take 5 minutes. Kindly see the notifications which have been filed.
My learned friend takes your lordship
to the CAN.
It should get an opportunity.
I'll just indicate your
lordship. It has not filed any affidavit.
1 minute.
Because the entire fact situation, I have a duty to place.
How does this affect
I just point out? I would request my learned friend.
Thought for. None of the petitioner had filed any objection. I'm told only one petitioner had filed an objection but did not turn up.
From 29th April till date, hearings are on. None of the petitioner participated in the public hearing. May I just indicate to your lordship? Now a submission is being made that these public hearings, lordship will kindly go through their application.
I will show.
The application says that it was not properly publicized. On 6th of May, we informed your lordship that it is being publicized. The regular notices are being published in the newspapers and they are free to participate. They did not participate. What they did, one of the petitioner in Puravidas petition, some Novendu Bhattacharya, something like that, that gentleman writes a letter on 20th of May that I wish to be heard. He doesn't attend the hearing. He says that I wish to be heard. Then the affidavits which we have filed, submissions are being made, that reports are nothing. Reports are basically, there is no rationale behind the reports. For each and every class, I will not use the expression community. For each and every class, there is an exhaustive report.
There is not.
Yes, please, my learned friend, I will request my learned friend to bear with me. We have, as a sample, we have provided 2 of such reports. If your lordship directs us, by tomorrow we will produce another 49 reports.
Place the reports.
And my lord, these reports were placed before the legislature as informed by the state legislature to us, because copy was forwarded. And the state legislature has taken some resolution, but that is not within our domain. That is for the state to submit. So, my lord, whatever reports were there, whatever notifications have been issued, I am not here to defend. I am here to defend the basis of the notification, because I have supplied the basis of the notification. My recommendations have been accepted. If my recommendations have been accepted, your lordship would have to, for each and every class, naturally, your lordship, that's a fact-finding exercise. Lordship will definitely do that. We are not shy of that. But where is the averment anywhere in these applications that this community could not have been conferred the class of OBC A or OBC B? Your lordship pointed out in your lordship's judgment that this has to be a dynamic data analysis based on quantifiable and identifiable data. As a result of this dynamic data analysis, some classes which were placed in OBC A are now in B. Some classes which were placed in OBC B are in A. My lord, I am not here to, this is not, my lord, a religion-centric exercise.
We have struck down the very basis of A and B.
Yes.
How you are dealing?
No, your lordship has not done. No, your lordship was pleased to hold that it has to be done. My lord, the process was illegal as held by your lordship. Your lordship has not held. Subject to your lordship's kind consideration, this sub-categorization is not permissible. Subject to correction, my lord, I will stand corrected, my lord, I will stand corrected. My lord, whatever I have read, your lordships have held that it was all state in the earlier round. Because state appointed the surveyor, state did this, state made this recommendation.
Yes.
So, my lord, so consultation, that process of consultation has been concluded in some cases. In 71 cases, 76 cases, this process is over. I believe notifications have been issued by the state and placed before the state legislature. 41 cases are still pending, are still undergoing, which also has these, my lord, these classes. Then, my lord, another set of classes are being considered pursuant to your lordship's direction. We have tried to follow to a T whatever your lordship had directed. These allegations are vague and too wide and too reckless. Too wide and too reckless to be made in a PIL just for the purpose of stalling a process.
We are not.
And kindly hear us, my lord. We are not shy of hearing. Kindly allow us to use an affidavit within 7 days. We'll file affidavit. We'll come back to your lordship and get the matter heard.
We are only saying,
Yes.
then, we have no powers, or we should not normally exercise powers on a legislative process, and
Yes.
we don't do it.
Your lordship.
Religiously abide by
Yes.
that.
Yes.
Because the theory of separation of powers is very important.
Right.
At the end of the day, you have placed a certain data before the legislature for its consideration.
Correct, my lord. Correct.
Now, the legislature may accept, may reject, may modify or do whatever it deems, or remand matter back to you. That is the wisdom of the legislature.
That's the legislative affirmation.
That is the wisdom of the legislature.
Right.
Now, at this stage, there is good, bad, indifferent, an application from their side,
Right.
questioning some issues or whatever, bald or otherwise.
Then, my lord,
And there is no response as yet to your affidavit in opposition.
absolutely.
Now, unless the pleadings are complete,
Yes, my lord. Kindly do that. Kindly
now,
give us a
till
short
such
date.
time, we suppose tomorrow,
Yes.
in the process of these 7-8 days, unlikely 7 days or another 3 days, 4 days.
I cannot answer that, man. I cannot answer that.
It is unlikely that the legislature will just pass everything and implement the data. Is that what
The legislature has passed. It has been passed.
Placed before the legislature, and this has been passed. These are the
Malad, advertisement has also been issued. Advertisement issued, everything has been started. Even today,
Malad,
even pending
the advertisement
test
has also
before
been issued.
But it has been laid before the
notified.
legislature, and legislature has approved that. But that is the process which has been laid down by the court, and which is
was it placed in the form of a bill, or was it placed in
no.
the form
It has
of an
been
amendment to the act?
it has been placed or laid before the legislature.
What has been laid before
Whether
the
in the form of a report as per the statute. As per section
statute, 93 or 2012?
93.
93, of course,
There is no action under section.
of course, 1993.
So as of